Mr Chair, I have two supplementary order papers that I'd like to speak to, and I'd like to acknowledge the contribution of my colleague Dennis O'Rourke and thank him for his support of one of my SOPs, which I will start with. It's SOP 216, and it does replace SOP 202. And I'd just like to read from that supplementary order paper, which amends Clause 568 of the Judicature Modernisation Bill, which amends Section 7 of the Te Ture Whenua Māori Act 1993. Section 7 relates to the appointment of judges of the Māori Land Court and enshrines in statute the long-established practice of judges of the Māori Land Court being appointed on the advice or recommendation of the Minister for Māori Development. In replicating the generic provisions contained in Clause 192 subsection 3 for appointment of judges, the bill would result in a failure to recognise the distinctive nature of the relationship between Māori land, Māori landowners, the Māori Land Court and the Minister for Māori Development. Of note is that Cabinet is merely advised once the decision about the appointment of judges is made, and that we have an opportunity through this legislation to ensure practice and statute are consistent. I'd like to reference a document that I received, or that I found from the Crown Law Office website, and it's dated the 13th of September 2016, and it's titled Judicial Appointments. The fourth paragraph says, and I quote, "The convention is that the Attorney-General mentions appointments at Cabinet after they have been determined. The appointments are not discussed or approved by Cabinet." So I wanted to make that point, that this provision of the Minister of Māori Development appointing the Māori Land Court judges actually isn't a Cabinet rule or a convention. It's become a practice, but there's nowhere in statute or in the Cabinet manual that actually reinforces that practice. But I also want to read something else from this communicado from the Crown Law Office, and it says, "The appointment process followed by the Attorney-General is not prescribed by any statute or regulation." And in fact, what this Judicature Modernisation Bill does is completely change that. It is going to ensure that the appointment process followed by the Attorney-General is contained in statute, because it will be contained in this piece of legislation. And my contention is that if you're going to amend Section 7 of the Te Ture Whenua Māori Act that enshrines in statute the process for appointment, then in fact this is the reason and rationale why we should be really explicit, as my supplementary order paper has been, in saying that the Attorney-General must seek advice or recommendation from the Minister of Māori Development for the appointment of Māori Land Court judges. So I am not sure what level of support I have across the House, other than from my colleagues New Zealand First and also the Green Party. I'm hoping that there's enough support for this to go through, because it certainly has support from Māori Land Court judges themselves and in fact the Māori community. Because I think inherent to the appointment is the mana of the position of the Minister for Māori Development, the mana of those Māori Land Court judges and the Māori of our whenua. So I'm hoping that the government sees this as a reasonable request and amendment to this piece of legislation, and that they will therefore support this supplementary order paper. The next SOP that I'd like to speak to is the one, in fact, that Dennis O'Rourke has advised that they won't be supporting, which is to ensure that the judiciary reflects gender, culture, cultural and ethnic diversity in appointments. And this particular SOP came from the review that the Law Commission did. So there's a document called Review of the Judicature Act 1908 towards a New Courts Act, and it was recommendation 16 from the Law Commission that inspired me to put the supplementary order paper to the House. So recommendation 16B, I've replicated the words there, that there must be regard given to the desirability of the judiciary reflecting gender, cultural and ethnic diversity. And there are other components of that particular recommendation that I'd like to bring to the attention of the House, and I chose not to include those in a supplementary order paper because I spoke to judges who have been appointed and those particular issues are addressed, and they are social awareness and sensitivities to tikanga Māori. Mr Chair, thank you, Mr Chair. All judges on appointment now receive social awareness and sensitivities to tikanga Māori training. They also have received social awareness of and sensitivities to other diverse communities in New Zealand. So I'm reassured that the current process of educating our judges to those particular sensitivities are taken care of. But what we can't move away from, and I asked the library to do some statistics about the judiciary regarding their gender, cultural and ethnic diversity. And I'd like to read some of those statistics. So on average, total men, women, there are 29.9% of our judiciary are women. And if we look at the, international comparison, Canada has 35.4%, Australia 33.4%, the US 33%. The interesting thing for me, however, is that women actually comprise 47.5% of lawyers holding practicing certificates. So nearly 50% of our lawyers holding practicing certificates in New Zealand are women, but we're only 29.9% of the judiciary. And the interesting thing, if you look at the meta-analysis of those statistics, is that there is a requirement, and this piece of legislation reinforces that you have to hold a practicing certificate for 7 years or more. And of that 43.7% of women lawyers holding practicing certificates, only 43% of them are actually eligible to become judges. And so what we see in the profession, I guess, is the historical professionalisation of men in the profession, because 80.8% of men have been in the profession and hold practicing certificates for more than 7 years. That's 5,091 eligible men as opposed to 3,844 women. So I can understand why there's a little bit of an issue because of that qualification. Women aren't being reflected in the numbers that we would expect as reflective of the number of women in the profession. Because if you look at it, we would have expected that 47.5% of judges were women, but that's not what we're currently seeing. The other interesting point is of the 243 judges, only 29 or 12% are Māori. And so I think if we were to reflect New Zealand society, then 16% of judges would be Māori. And in essence, what this particular supplementary order paper is trying to do is to have the judiciary reflect New Zealand society. The State Services Act doesn't do it. In fact, and I looked through the State Services Act and the functions of the Commissioner of State Services, 6D, it's to appoint leaders of the public service, but there's no regard to gender, cultural or ethnic diversity. So I think that we have an opportune time with this Judicature Modernisation Bill to actually put some minimum levels of acceptability into this piece of legislation about what we want the judiciary to look like. And we want the judiciary to reflect New Zealand society, both in terms of the representation of women, the representation of Māori, but also the representation of other New Zealanders. And what I didn't get from the library, and it's obviously because the statistics don't or aren't regularly kept, is the number of ethnic judges that we have in our system. And so I did a little Google, and I know we've got 2 Samoan judges. We have Judge Epati and Judge Malusi. Judge Sandre Patel was only sworn in on the 22nd of June this year. And also we have the first Tongan judge, Mina Wharepodi. But other than me Googling, we don't regularly collect ethnicity statistics in terms of the demography of our judges. So I've put this supplementary order paper to the House because I think, like everything, there's a time and a place to make a stand. And our police force have made it this year. They've committed to 50-50 women in the police force, and 50-50 women reflected in all the positions across the police force. And I actually think that it's about time that any piece of legislation, and a piece of legislation like this that's trying to modernise our judiciary, actually reflect those sentiments, that we want a judiciary that reflects New Zealand society. So I implore this House to support that particular supplementary order paper. Kia ora.
Chair.